Okay, so I'm very happy to open this event, the Minerva Center for the Rule of Law Under Extreme Condition. Our guest today is Dr. Haim Abraham. Haim is a lecturer at the University of Essex School of Law and starting January at the UCLA Faculty of Laws. He holds a Doctor of Judicial Science degree from the University of Toronto, a Master of Law degree from the University of Cambridge, and a Bachelor of Law degree combined with the interdisciplinary honors program in the humanities from the Hebrew University of Jerusalem, where he was on the editorial board of the Israel Law Review. Before returning to academia, Dr. Abraham served as a law clerk at the Israel State Attorney Office, Civil Department. His research and teaching interests include tort law, private law theory, liability of public actors and authorities, the intersections of private and public law, and gender and sexuality law. Haim, the floor is yours.
Perfect. Thank you very much. I'm going to try and share my screen. I hope, did it work? Can you see the slide? Perfect. Yes. So thank you very much, both for the kind introduction and for inviting me to give this talk today. I'm going to use my time to give a very broad overview of this project without diving into too many particular details. And I think that when people think about tort law and war, they think, what do these two have to do with one another? There is no tort law and war. And if that's the way that you're thinking, then you're absolutely right. Recent events have showed us that states have various practices when it comes to warfare, and many times there would be terrible mistakes and civilians would suffer various injuries, but states are actually immune from tort liability for inflicting those injuries, even when you have clearly negligent mistakes. We can see that immunity exists throughout the common law world. You have it in the US, you have it in Israel, you have it in the UK. And what usually happens is that instead of having a claim, a right to claim some kind of compensation, then civilians are able to ask for some kind of payment or redress, but that is something that is a matter of the state's discretion. And what I'm going to talk today is, first, I'm going to talk a little bit about the immunity from liability, which is often referred to as the combatant activities exception. I'm going to talk about the basis for it, the justifications that are given, and I'm going to generally show that these justifications fall short from being sufficiently convincing, that not only tort law can apply during war, but actually it should apply during war. And I want to start by framing this project. This project is not concerned with liability towards combatants, whether it's states-owned combatants or enemy combatants. Instead, it's focusing on liability in tort towards civilians. So when we think about the combatant activities exception, there are two main types of justifications that are usually brought forward. One is that tort law simply can't apply during warfare, and the other one that tort law shouldn't apply during warfare. If we look at the first justification, then we can see two different arguments. Perhaps, again, it would be a good idea to start by framing what it is that one needs to show in order to be able to establish a claim in tort. Usually, you have to show that you have some kind of right, that individuals had a duty to refrain from infringing or violating that right, and that they did that while acting with an insufficient degree of care. That's, generally speaking, the structure of tort law. And the arguments that go about asserting that tort law simply can't apply during war try to tackle these various elements. So one type of arguments is that there are simply no relevant rights during war. Rights can be overridden or suspended, or maybe there are other considerations that override or take precedent, Or maybe there are certain types of injuries that are simply permissible to inflict on civilians. And for whatever reason that may be, we can think or talk about rights in a way that they are irrelevant. And because they are irrelevant, then there is no way to actually violating them in a way that would trigger the structure of tort liability. So that's one type of argument that is being made. Another type of argument that's being made is that during war, we can't really talk about a duty to take care or to take sufficient care towards other people. Either because the duty itself doesn't exist, war is simply too chaotic, we don't want to burden our combatants with this idea of taking care to not injure civilians one way or another. Or maybe there isn't a standard of care that can be used. Maybe we can think about a way to be careful enough during war. Maybe that's just an ideal that doesn't exist. So that's a different way of framing the conversation. And we can see that coming in, for example, in the Smith case. So this is a UK case that was brought by families of deceased members of the armed forces who were deployed in Iraq and were killed either due to friendly fire or due to IEDs. And the families argue that the forces didn't receive proper training and proper equipment to make sure that they won't die under those circumstances. And what you can see there is that Lord Hope in the Supreme Court is saying basically that there are certain times where we can say that we can think about a duty of care and standard of care in the context of warfare, but that is not something that will happen as war is being waged. It might happen before at the training stage, maybe after at the redeployment stage, but not during active operations. In those instances, there isn't just enough time or the resources to take the required precautions and to think about things in a way that tort law usually requires. So we can see that we have that type of arguments that say that tort law simply can't apply to war. A different type of argument is that even if tort law can apply during war, we want to say that it shouldn't. And there are a variety of instrumental reasons for why that is. We might fear that if tort law was applicable, then combatants or states would be over-deterred from taking all of the necessary steps they need to take in order to achieve their goal. Maybe they're not going to enlist to begin with if they have the choice. Maybe they're going to hesitate for that one split second, and that will cause some kind of catastrophic loss. So there is that type of fear. There's another fear about inequality in compensation, that if tort liability was available, then maybe you can see instances where you have two different individuals sustaining the same type of losses, but one of them will be able to have a claim in tort and the other wouldn't. So think about two neighbors. Both neighbors' houses were destroyed in a bombing. One was permissible collateral damage. The other one was a negligent bombing. So perhaps on that account, the negligent bombing scenario would trigger a claim in tort, and the other one won't. And maybe that appears to be causing some kind of inequality. There is also some fear about punishing combatants. If we impose tort liability in a way we're condemning their actions, maybe we're even imposing liability on them in particular, something that I don't think can actually happen, but let's say that maybe. And in that sense, we are punishing them or to a certain degree, right? We're holding them accountable for something that we might not think that they should be held accountable. They're operating usually outside of the state's own jurisdiction, right? They're trying to promote the interests of the state rather than their own personal narrow interests at a very high personal risk, and maybe an imposition of tort liability is inappropriate in that setting. But what I want to argue, and what I do argue in this project and through various publications and means, is that these types of arguments, these justifications, they just don't seem convincing enough. They don't seem to actually be able to maintain or make sense of the existence of the exception, especially in its current scope, which is quite wide in all jurisdictions that I've looked into. So the first thing that I want to show is that tort law can apply. And the reason why tort law can apply to begin with is first that rights remain relevant during war, but also we can have an idea about a duty of care and a standard of care. Now, the way that I establish that rights remain relevant is by looking at the arguments that rights are irrelevant during war. And if we take them seriously, then we start seeing that they're very difficult to accept. And they're very difficult to accept on two different grounds. If we think that rights are entirely irrelevant during war, then we start seeing a variety of institutions and legal doctrines that don't make a lot of sense. If there are no rights during war, we can't really understand why they're there. And we can talk about the law of war, we can talk about various UN bodies. All of those don't necessarily make sense if we say that there are absolutely no rights during war whatsoever. Maybe it would be easier for us to say that maybe during war, certain types of rights and their enforcement is severely more limited or is more difficult than during peacetime, especially if we think about private law rights as opposed to international law rights. But it seems that very intuitively, we can say that rights are relevant during war. People don't lose their right to life. They don't lose their right to property. If that was the case, then we wouldn't need all those laws that tell us that we have to distinguish between combatants and civilians. We would be able to just walk up to any property in a battlefield and take it because it would have no owners, but clearly that's not the case. So we can see that rights remain relevant during war, at least to a certain extent. And if rights remain relevant during war, then certain things follow. The first thing that follows is an ordinary duty to ensure that you don't wrongfully infringe those rights. What would amount to a wrongful infringement? Well, first off, any type of loss that you inflict during war would be a prima facie wrong. It would be wrongful. And you would have an ordinary duty to redress that wrong. But again, if we follow this account, then it seems, again, quite odd because it would be over-inclusive. We would see that states would have to compensate every individual for every loss that individual sustained during war. And that doesn't seem to align with what we know about what states are able and are allowed to do during war. They're allowed to inflict certain losses during war. And my account is trying to align the authority of the state under the law of war and the tort law regime that we should have. So we don't want to have a blanket immunity regime because that appears to be entirely contradicting what we know about the law of war, but also we can't have a regime in which every loss would be wrongful. Again, that appears to be in contradiction with the law of war. So what we want to have is an account that is mindful of the authority that states have. And what I argue is that losses that are inflicted on civilians are prima facie wrongful, but as long as they're inflicted while a state is acting within the scope of its authority, so as long as it's complying with the law of war or with the rules of engagement, then there is a justification for these losses, which rules out their wrongful nature. But if the losses were inflicted in violation either of the law of war or the rules of engagement, then that justification doesn't stand up, and that particular loss is wrongful, and there is this ordinary duty to redress that wrong. So with using this structure, we can see that tort law can apply during war. And I think that we have to note that to date, there is no in-depth theoretical analysis by courts or legislators about this assertion that tort law can't apply during war. We have very brief sentences in a few cases here and there. In Australia, in Israel, we have a whole paragraph in the US, in the Coohey case, which is the leading case so far, but we don't have a very in-depth, rigorous analysis. So I think that using this account provides such a standing, such an analysis, and it shows that tort law can apply during war. So the question is not whether it can apply, the question is, do we want it to apply during war? So that makes us shift our attention to the various instrumental considerations. And the first one, which is, I think, the most vocal one, is about over-deterrence. There is this fear that if tort liability is going to be imposed, then combatants or states are going to be over-deterred from engaging in combat. And based on an empirical study that I've recently conducted and that is now coming out with Law and Social Inquiry, so shameless promotion, it's already available in an advanced form. But what we can see from there is that not only does tort law not over-deter, it actually under-deters state actors. Combatants, politicians, government attorneys, they all don't think about tort law. They don't take it as a factor when they consider whether to engage in combat and how to engage in combat. They care about achieving the military goals that they've set, neutralizing risks. They care about complying with IHL. They don't care about tort law. And they don't care about tort law because they know that the state has deep pockets. It can always plan ahead and find ways to pay for whatever it is they might be liable for. Combatants don't necessarily have free choice in the matter. They're ordered what to do. Their choice is limited. And they don't internalize the costs of wrongdoing. It is the state that actually bears and shoulders these costs. So we can see that the various elements that are required in order for there to be deterrence to begin with are not really there. So the fear about over-deterrence appears to me to be slightly exaggerated, but tort liability has something that's quite unique and interesting in the following sense. The more tort litigation occurred, and the more liability the state was, in theory at least, exposed to, then we can see this side effect where there were less and less instances in which the state was being held liable. But that wasn't because the state started acting more carefully and learned from its mistakes and negligence and changed its rules of engagement and practices. What happened instead is that states expanded the scope of their immunity. And we can see that in Israel, and we can also see that now in the UK. There is an expansion of the combatant activities exception, an expansion of various procedural modes to discourage plaintiffs from applying and pursuing litigation. And if you look at this graph, then it's trying to track cases where Palestinian tort claims against the IDF where there is actually a ruling by an Israeli court about whether the combatant activities exception applies or doesn't apply, and therefore whether there can be or can't be a claim. And what you can see is that more or less about the beginning of the Second Intifada, you have a variety of approaches. Sometimes you have liability, sometimes you don't have liability. There aren't a lot of cases, but starting with the Second Intifada, there was a very large amount of cases that were being brought forward. According to the state attorney office arguments in the various committees about expanding the combatant activities exception, there was close to 1,000 cases that were being brought. And around 2001, 2002, you start to see a shift, and you see a sharp increase in the number of cases that are being rejected. And that coincides not only with a change in the way that combatant activities were engaged in and a change in the nature of the conflict, but also with a very important precedent in the Supreme Court, the Bani Uda case, and a change in legislation, which was Amendment 4. And you can see that through both of these instances, there is a significant expansion of the combatant activities exception from what it used to be, which was this vague exception that applied to what was usually and mostly referred to as actual warfare, to then operating for things that apply to policing activities, activities where the combatants are not exposed to any type of risk. So for example, drone strikes or artillery, but also for instances where the combatants subjectively believe they might be in danger, not imminently, but sometime in the not too distant future. So you have a temporal expansion, you have a normative expansion, you have a geographic expansion of the exception, and you can see that through that expansion, there are less and less cases where liability can be imposed, and the number of cases that are being brought every year is very low. It could be counted on one hand at most at the current rate. Another thing that we want to think about when we think about the instrumental accounts and try to perhaps think about them and maybe resist them is what we currently have. So currently, non-nationals are able to receive some kind of payment through ex gratia payments. These payments are usually not grounded in legislation. They're fairly random. There is no consistency when it comes to different people bringing claims under similar circumstances. There's no consistency necessarily in the nature of injuries. You can see that there are all sorts of hurdles, like language hurdles, actual ability to bring a claim physically in, information about the availability of remedies, and the ex gratia mechanisms. There is no appeal mechanism. There are all sorts of issues that relate to these ex gratia payments that are discretionary and not transparent, and are being conducted usually by the same body that actually inflicted the injury. And these are obviously also fairly low in comparison to an equivalent tort claim that might have been successful. So that's what you have for foreign nationals. For domestic nationals, you have some kind of quasi-insurance scheme that's operating. So you can see that combatants and even civilians might be able to receive remedy for injuries, for loss of property, damage to property, through various insurance schemes. And they have a right to claim those remedies, and sometimes they're being actively sought out in order to pay them, which is again something different. So arguments about equality, arguments about what would be the best type of way to redress these losses, they can vary, and I think they're contingent and empirical, but the current regime does not look very effective. And even if it was as effective as tort litigation, or maybe as tort litigation can be, it's still important to keep in mind that when you move away from tort liability and tort litigation into the realm of insurance, for example, you're losing something that's very important and unique to tort litigation. And that's the ability to go to a court and get that court to provide a ruling that said that somebody wronged you and somebody owes a duty to redress that wrong and make a right out of that wrong and restore your relationship. And that is something that could be very important, both on the normative level, but also in other ways. It could be important for other elements of justice and peace and prosperity between parties, if they can bring that claim and settle that animosity between them in that way. So if we look at the character and structure of what I'm suggesting. I'm suggesting that tort law would apply in a very ordinary sense. Claimants will bring claims to the courts of the state that inflicted the injury on them. They will pursue those claims through ordinary tort law and the ordinary doctrines that we have, although obviously they will be, in a way, they will be slightly different due to the different standard of care that you would have during war that is more attentive to what you can and cannot do during war, which is different from what you can and cannot do during peace. And the fact that that standard is different means that tort liability would be available, but it would be narrow. It would only be available when the laws of war or the rules of engagement are infringed, are violated, and that is a fairly high bar to meet. So tort law would be a partial remedy, but not a remedy that would suffice for some people who are trying to argue that all losses that civilians suffer during war should be redressed as a matter of rights. So that is my main argument in this sense. And the last thing that I want to flag and talk about, which is particularly problematic, is cyber warfare and tort liability. And it's particularly problematic for two reasons. I will touch upon one in a bit, but the first one that I want to mention is that if cyber warfare is part of warfare, then it makes sense that combatant activities exception would apply to it as well. But it seems that many of the rationales about it don't really apply to cyber warfare. There is no risk to the combatants that operate that activity. It's done remotely. There is a high risk to civilians. But perhaps the first thing that we should do is to define the different types of cyber warfare. So you can think about kinetic cyber warfare. Somebody takes over a car and that car crashes. Maybe you cause a few centrifuges to spin around quite quickly and they're destroyed. Maybe you destroy a laptop from remotely. So that would be one type of cyber warfare. Another type would be a disruption of services, no internet access, no phone access, and so on. And the third type would be disinformation and manipulation of information. And we can see that to various degrees, there is disagreement about whether the law of war applies to these types of cyber warfare. I think there is more agreement about kinetic warfare or kinetic cyber warfare that IHL would apply there, and significant less agreement when you go to the other end of the spectrum about disinformation and manipulation, about whether IHL applies there. And the problem is that well, two problems arise here. One is that cyber warfare opens the door to a lot of different possible torts that you don't necessarily see in the same scope when you talk about regular kinetic, traditional face-to-face combat. You can see all of these things as well, but not necessarily in the same scope and the same intensity as cyber warfare, which in the click of a few keyboard buttons, you can gather a whole bunch of private information from a lot of people. You can destroy a lot of property in a fraction of the time and a fraction of the cost. And you can see that you have that issue about whether the law of war applies in the context of cyber warfare. If it doesn't apply, then my entire argument that I've built so far seems to be inapplicable as well, as it is based on this idea of the law of war being relevant and applicable. And so we would have to think about something else, or maybe some consequences. We also have issues regarding anonymity. We don't know if a particular hacker is engaging in cyber warfare, or is it a state? And that's something that's important for the ability to bring a claim. If the law of war doesn't apply, then we can see that we have problems with over and under inclusivity. If it doesn't apply, maybe everything is a tort, because the states have no authority to engage in warfare. And if they have no authority to engage in warfare, then everything is a wrong. So everything would be a tort and everything would have to be compensable. Alternatively, maybe the law of war applies to all types of cyber warfare, and there is just no concept of what would be a breach of the law of war in the context of cyber warfare, and therefore nothing will be a tort. Maybe there's some kind of under-inclusivity argument there. But I think that the important thing to take into account in this context is that, first of all, we can see that whatever argument we might take and whatever direction we might lean to, cyber warfare is not a legal black hole. It's not something that's unregulated by a body of law. Maybe it's regulated by the law of war. Maybe it's regulated by tort law. It's not a black hole. Maybe it's a gray hole because we don't necessarily know exactly what type of liability regime, what type of laws would apply there. We can also see that tort liability could be a partial solution to people who sustain damages through cyber warfare, but there are significant hurdles. So it's not a perfect solution. But maybe we can start talking about a few things that would be considered a new normal, and therefore there wouldn't be torts at all. So today, if you walk down a busy train station and you bump into somebody's shoulder, that won't be considered a battery, even though it's not a non-consensual touching of another person. So maybe we can start thinking about certain types of activities online, like misinformation, like manipulation of data, in the same kind of way. That's just something that happens online all the time. It's a type of normal, and unless something else is added into that equation, then there shouldn't be liability for these types of activities, even if we do say they are cyber warfare and that the law of war applies to them. So I'm going to stop there, and I thank you very much for your attention, and I really look forward to our conversation.
And thank you for your brilliant talk. Congratulations also on the Law and Social Inquiry publication and the forthcoming move to UCL. Please, those who want to ask or comment, please raise your hand or write in the chat. I will ask you a first question, maybe, with regard to your first part of the lecture. And I understand the motivation and the sympathy, but I'm not sure if torts as a principle is really relevant for this war situation in the sense of equality that you mentioned. Why? Because, you know, torts focuses on the wrongdoer. And in wartime, people get hurt, innocent victims, and innocent victims can be, you know, innocent victims by a totally legal act or act that would not be ruled in a general context of torts law as torts breach. And some other people, you know, are victims of a war crime or something that can materialize into a tort. So if we focus on the victims, and I think that the idea is to compensate the victims, and this is a total different idea than the international criminal law, I think that we should find, or we should legislate or framework the existing kind of compensation scheme that will, you know, maintain equality and due process and all the other requirements, but will be focused on the victims and not on the wrongdoers. So the question is whether, you know, we had several years ago a conference in which the guy who was appointed by George Bush after the Twin Tower disaster or terror attack to allocate compensation to the victims. And this was an amazing operation conducted totally outside the regular realm of law. It was not lawsuits filed in courts with all the proceedings and the huge costs. And he actually managed, he was called to duty because I think he did it in previous rounds also after the oil spill, or I think Deborah will be able to.
That was the oil spill was his big, was the precedent and why he was chosen, but he's done a lot.
Yeah. And it was very, very, well, everybody appreciated and rated his operation brilliantly, you know, and the satisfaction from the compensation scheme I think I can predict would have been, is much better than would have been if torts cases, so many torts cases would have been conducted. So, so this is my question remark. And I see that Robert is next online. So, Haim.
Perfect. So I think you actually asked here a couple of different questions, and they're both interesting in different ways. So one question was about whether tort law is a good mechanism as such, just because of its focus. The other one was more about, is tort law better than other mechanisms? So I'm going to start with the first one. I think that there is some degree of theoretical disagreement about the focus of tort law, whether it's focused on the wrongdoer or on the injured individual. But I think that we can actually set that slightly aside and instead focus on something else that I think is more important in that sense, which I think was actually where we were going with this. And that is the degree to which different focus would mean that you would have different rules. So for example, if you're more focused on the wrongdoer, or maybe the degree to which the wrongdoer can act in various ways, then maybe the standard that you're looking for is one that's more focused on negligence rather than a strict liability standard, as negligence would allow for certain activities to take place, whereas a strict liability standard would apply regardless of how much care might be taken. And I think you can follow, Yalwanen has a very fantastic paper in this context, and she flags this difference. And perhaps if our main goal, if our only goal is to compensate civilians, and that is our focus, then we want to maybe want to have a strict liability rule. Maybe we want to have something that's entirely outside of tort law whatsoever. I think that I would want to, I don't know if resist that would be the right kind of way of framing where I'm going with this, because my argument, and this maybe goes to your second question, my argument isn't that tort law is the only way that we should proceed. It's not even that the tort law is necessarily the best way to proceed. Rather, my argument is that current alternatives are not good enough. They don't provide the goods, so to speak. And tort liability in this sense, when you take lots of different considerations into account, the pros and cons of different things that might be available between tort law, exoneration payments, insurance scheme, then tort law seems preferable in this context, as it provides a right to individuals to bring a claim. It provides them with this statement that they have been wronged. It provides with an attribution of accountability. All of these various factors, I think, are significant and important. And then if you do go with tort law, then you have to decide about what type of liability regime you need to have. And I think that the one that best fits what we think about states are allowed to do in the context of warfare, then that's a standard of negligence rather than strict liability. But all that being said, I agree with you that if we do have a different focus, or maybe if we do have another idea in mind, maybe we can try and do that. Maybe we can try and implement that. I just think that experience shows us that so far there isn't a political will to do something else. And the things that do exist don't operate as well as tort liability regime. Not to say that there will be a political will to eliminate or minimize the combatant activities exception, but I think that at least the framework that I'm trying to suggest provides some kind of arguments and some kind of pushback that can be brought forward and provide that political pressure that is needed to make that change.
Thanks. Robert.
Hey, hello, and first of all, thank you for a very interesting presentation, Haim. I have several issues to speak about it, but I have conceptual differences probably with you on the application of tort law, but I will focus first on the, I think, most important practical issue that is to refer to, and I think it's the difference that should be between violation of IHL norms and ROEs, or rules of engagement. Rules of engagement are, as you probably know, are policy-oriented rules. They do not only reflect legal norms, like they do not reflect the violation will not necessarily be an infliction of a crime. It will not be a crime or a violation of any other international norm. At least it could be affected by like policies, like the state is trying to conduct an act of war without political consideration. You don't want any civilian killed, for example, okay? While IHL can allow you, in some cases, as a collateral damage, of course, to find some civilians killed in action. These are internal rules and policies that I do not understand. I'm happy to, if you can reflect on this. I don't understand why a civilian on the other side should enjoy that. And if it was for him to enjoy for that, that would be a consideration for the country whether to write such rule of engagement. Because if it will cost money for a country, I would write, and I will have to say that I was in charge of writing these rules of engagement one time in my past. I would write it in a very broad way, in a way that the country cannot be sued later in torts for it. It does the opposite. As you are asking at the end of it, it loosens the outcome would be more difficult, I think, for the other side here, and that's the main issue I want to reflect on. I think while I understand the need for some compensation in cases of IHL norm violations. And in these cases, in very harsh cases, and these are norms that are all regulated and planned for the extreme environment of war. And if you infringe them, if you have a violation here, you have done something which is very, very wrong. Okay, and in that case, criminal ICL, international criminal law will go into the picture. In many cases, not necessarily, but in many cases it will. And you can understand that even some compensation for the victims should be awarded. But whether that's I think that in the policy, when the country sets its policy rules for itself, then it's something completely different. I also have to say that I have some, as I said, some conceptual differences with you. I think that the cyber example simply explains what's the problems in implementing tort law in war, because the standards are probably a bit different, and many infringements, many tort infringements will not be necessarily have their own weight, and if And I think most people think today that in cyber warfare, IHL will apply. I think there's no more question about it. But I think only it reflects the difficulties of implementing such norms. There's other issues here to consider. For example, other international law norms, not necessarily from IHL, acts of states, states' immunity, and other norms that rule allow. There's no option to sue in negligence today a state outside war, because a state has, under international law, an immunity to be sued for actions. So going all the way, skipping all this just to getting just in saying, okay, in war, in the most difficult cases, in the most extreme case of an act of state, in that case would be you will apply tort norms. It's a bit difficult to me, and also shakes not only this IHL and war state, regulation of war. It may have effects on peacetime international law norms too. Thank you.
Great, fantastic. Thank you so much for these questions. So I'll start with your first one. I completely agree with you. There is a difference between IHL and rules of engagement. Absolutely. And I think that as things stand at the moment, rules of engagement tend to pose a somewhat lower bar if you try and bring that to a court. And the reason why it's a slightly lower bar is that usually they're easier for courts to digest for a variety of reasons. For example, judges might have some kind of experience, as is many times the case in Israel. They might have experience with the rules of engagement, but also they're very detailed. And judges, when it comes to tort liability, find it that there's something that is appealing in adopting some kind of common practice that is unique to a profession or to a context, and they can, if they want to, they can adopt that and implement that. And so I think you're right. There is this danger that if tort liability was applicable, then what the state would do, it would just change its rules of engagement to avoid liability. I think that two things should be taken into account in this context. So one maybe is going to be a little bit idealistic, and that's the thought that there should be better separation between different state actors. You should have a separation between those state actors that relate to the actual military operations, those that relate to politicians, those that relate to government attorneys that are in charge with defending the state in these types of claims. And I think that once you see that you have that separation, then maybe there isn't going to be as strong and as clear of an interest to implement such a change to the rules of engagement, and instead they're going to implement different types of policy that might be at play. But even if we don't do that and we move away from that idealistic standpoint, and instead we're going to say that, yes, that's something that might happen, there is no way in which you can have rules of engagement that are going to go against or undermine what states are obliged to do under IHL. States simply are not allowed to do that. You can't have your rules of engagement that say, yes, you can target civilians directly while acting and imposing disproportionate laws. I can see you disagree with me here, or maybe I'm mistaken because you have a small...
On this point, I completely agree.
Okay.
No rules of engagement can go and give bigger rights or privileges than IHL. There's no question about it.
Yeah, perfect.
And there can be other relevant laws that apply too, not only IHL. But,
yeah, exactly. So in that sense,
I'm referring to the gap between legal duties and policy, and there is a very big difference, in my opinion, between the two.
And I agree, and I think that in that sense, I'm happy with IHL acting as a ceiling that you can't go above and you can't raise, and the rules of engagement will be somewhere from that point on downwards. I feel like I'm happy with that, and that's something that's possible. That change can come about. What I think the reason why I do refer to the rules of engagement is because courts are more likely to be able to implement them more easily as an actual practice and as a way to think about the standard of care, as opposed to IHL proper, which is in some ways more abstract and amorphous, and courts don't really do a lot to deal with it at the moment, so they don't really know how to engage with it. So that's a way to kind of try and think about that.
My point on this was that is that enough? If this is we are speaking about the implementation, it's easier, but it's not. There's a conceptual issue here. There's a conceptual issue of why should a citizen of the other side enjoy an internal restraint that you put on yourself, okay? Whether if it's a legal violation, okay, if it's an infringement of your rights or his rights under international law, there is no question, okay? But the conceptual issue is why should someone on the other side enjoy something? And if it's easier to the courts, I think it's not a convincing argument, okay? So the courts should do the hard work. It's not just go to the easy work and see, okay, it's written here that you can't do it. That's my point on this issue.
Yeah. So to answer that point, at least my account is really focused on states' authorities and individuals' rights. So an individual doesn't enjoy from the state's rules of engagement. The individual has a right to their body. They have a right to their property. And that's something that they enjoy. Now, the thing that states are able to do, or the way according to which they're able to act, is constrained by various laws. And in this particular context, what I'm arguing is that the rules of law, the rules of engagement and IHL are relevant to understand what is the scope of a state authority to act in a certain way that would mean that it's justifiable to inflict certain losses. It's justifiable to kill that person or injure that person or destroy that person's property in that context. And when that's not justifiable, then the person is not benefiting from the rules. The person is just enjoying their ordinary right to life and property and so on. That's the thing that I'm focusing on in this context. And as for your second point about cyber operations, I completely agree with you that this is a very tricky realm, and I think they flag a lot of difficulties. They create more difficulties and new difficulties because it's a different platform and because of its scope. So I don't disagree with you on that, and that's still something that I'm working through. So my arguments about cyber warfare are still kind of very general and abstract at the moment. One thing that maybe I want to flag is you mentioned active state, which is a particular different doctrine from the combatant activities exception. The active state doctrine is usually used in certain contexts to try and say that something that was inflicted during warfare is immune from liability. And courts tend to resist this argument more and more in a variety of jurisdictions and saying that it is a limited doctrine. It's very messy. Over centuries, it referred to different things. So there's lots of confusion about this doctrine. But at least for the parts that are relevant to warfare, those appear to be in line with my argument, and they're limited to the degree that violation of IHL would not qualify as something that would come under active state.
Thank you, Haim. Ido, please.
Hi, Haim. Thank you for that very interesting presentation. I have several questions, but I'm going to limit myself to 1.5 just for the sake of time. The first one is, well, how can you actually prove a violation of IHL as a plaintiff in tort law? Because, well, usually it takes actual commissions of inquiry and fact-finding missions to actually identify violations of IHL. So let's put aside the question, the gap between rules of engagement and IHL violations, but still the private individual who suffered damages it's going to be almost impossible on that person to actually raise to the level to show that there was enough of a violation to change the burden of proof to the state to prove that they didn't. And well, we can actually assume that if that would have been possible, in most cases, the state would automatically pay just to avoid from disclosing any intelligence that they had that led to the specific attack. So that would be an interesting situation, but I also think it would be almost impossible situation, as we see that it's very, very difficult to even claim that there were certain violations, because usually you would have at most the ex post facto information at all, and you wouldn't have any of the previous information that led to the attack or whatever it was. And my second question is about recently the Human Rights Committee in General Comment 36 talked about the fact that even if states follow IHL, they might still be in violation of the right to life if this is an act of aggression. They didn't say it explicitly, but it was implied in the general comment and a little writing following that. My question is, do you think that that concept of who, if someone is the aggressor in that conflict, should that be a factor in that tort claim of who is actually responsible for the damages?
Great. So I'm going to start with your second question, because I think I can do that within a very short time span. My account is one that is based on the idea of use in bello, not use ad bellum. Whatever factors there might have been to decide to engage in warfare, those are not factors that I think are relevant to deciding about whether it was okay to actually engage in warfare. And I know there are lots of disagreements here, and there would be those that would say that it's impossible to make this distinction in any kind of coherent sense. But I think for the sake of time, I'm going to suffice by saying that I disagree with them. My account is one of use in bello. So those types of problems that the Human Rights Committee raised, they're not going to come from my account if people actually decide to follow this account rather than take a different view. As for the other question, it's a very difficult question about how would you actually decide these cases. I think there would be some instances where it would be very clear that there was a violation of some kind. I think that maybe you can try and argue that these would be along the similar lines as the Israel Supreme Court case where you had the neighbor protocol. So those would be clear instances. So that's not something that's going to be too difficult to do. There could be some instances where I think the state is going to be willing to pay in certain ways, like you said, or at least willing to admit that something happened. Maybe not violation of IHL, but maybe violation of the rules of engagement. Again, this is another reason why I think this is a good thing to use. Is it's much clearer whether those rules were followed rather than IHL. So was the weapon fired in the right kind of sequence, in the right kind of angle? Was the right kind of ammunition used, and so on? So that would be easier to do and solve. And I think that some instances, you can see that states are actually admitting that there was some kind of wrongdoing. This is what happened in the U.S. very recently. In Kabul and in the past in Kunduz, I think that Israel was happy to admit that it targeted the house of Dr. Abulaish negligently, or at least mistakenly. When I worked at the state attorney office, the state actually admitted that there was human error by accident, but then it was protected from liability. So maybe that won't happen if there is liability. But then there might be some difficult cases. And I think for those reasons, you might want to have some kind of ability to review evidence that are confidential. Either you can have meetings in closed doors, maybe you can have a special tribunal that is going to be dedicated for that, or you would have attorneys that would have the classification that is needed to have access to these evidence. Those are sorts of solutions that already exist around the world in different contexts and could be adopted if that thing came to be. But you're absolutely right. It is very difficult. And I think, like many regimes that are going to be new, it's something that would have to be taken into consideration and into account. But perhaps if my argument is not going to be taken in full, and you're not going to see a total abolition of the combatant activities exception, and instead all you're going to see is a minimization of its scope, then that's something that courts are, again, quite very used to do. And you don't necessarily have to follow IHL. I think they follow some principles of common sense, but mostly they follow the rules of engagement and see whether those are followed or not.
Zecharia.
Thanks.
Unmute yourself, please. Zecharia? We cannot hear you.
Now, okay. You hear me?
Yes.
Yes.
Okay. I'm concerned with the applicability of the tort liability notion in general and in particular nowadays. On the one hand, tort liability seems a natural result of IHL or jus in bello in a certain degree, when we are dealing with warfare engaged between states' armed forces, which are distinct when there is a distinction in a certain degree from civilians. Nowadays, belligerent activities between states' armed forces are mainly against terror organizations that operate within and from populated areas, for instance, Gaza Strip. So in such cases, I doubt if tort liability can be and should be applicable. This is my question.
Okay, great. So I think one of the good things that I like with this question is that it flags something about the framework that I'm suggesting, and it's poking some holes in it. So my framework is based on, like you rightly argue, on this traditional account of warfare. It's kinetic warfare. It's between two states. There are different issues that come about when a state engages in combat against a terrorist organization. That's something that's slightly different. I think that despite that, you can still see, and I think this is generally agreed, that IHL still applies in various changes. You still have the rules of engagement. And because my account is focused on the idea of what is within the state's authority to do, and that is something that would be used to justify violation of individuals' rights, then you can see there is a way to bridge the gap between traditional warfare and what we have now more commonly. So even though there might be some other issues, or maybe there would be some difficulties that would come up. Maybe there are going to be more instances where civilians might be injured. The same kind of principles are still going to apply, and you're still going to be able to analyze them in a very similar way, which I think is sufficiently similar to say that you can then transpose them from traditional warfare to counterterrorism activities to cyber warfare. And not to say that it would be entirely seamless, and maybe there would be some changes in the scope of states' authority, but individuals' rights remain relevant, and states' authority remains as a concept that's helpful to inform that liability regime. So I think we can still bridge that gap.
Thank you. Thank you, Haim. Galit?
Thank you. So I'll just introduce myself. I'm an attorney with the Ministry of Justice in the International Law Department. Obviously, these questions are in my personal capacity. Haim, it's nice to meet you. I've heard a lot about you.
Very nice to meet you too.
Some of my questions have already been addressed, but I want to hone in on one or two issues. You mentioned earlier that damage and harm to civilians can sometimes be a result of collateral damage, which is in accordance with international law and IHL. It could also be a result of negligence, and it can be a result of a malicious act or of an offense involves intent. And from a humanitarian perspective, from the victim side, there isn't necessarily a difference if harm is caused. But from a legal perspective, I think our starting point is that there is. If I understand correctly, your baseline is that harm caused as a result of collateral damage, for instance, would not require the tort regime because it's within the framework of IHL. And then that leaves us with, I would say, negligence and intent. I think one of the rationales, which I don't think I saw in the presentation, for why some people would argue that tort law is inapplicable, you mentioned sort of a freezing effect, the fact that military service is conscripted and people don't have free choice. But another one of the aspects is also the fog of war element. That there's a lot of chaos on that field, and that there's more room for human error. And so my first question would be, do we necessarily want to treat negligence in the context of conflict the way we would in the regular tort regime? Because that is actually one of the strong reasons for why the tort regime is inapplicable, because you have a lot more room for human error or for mistakes, even when the results are very tragic. So when we're talking about liability, do we want to pose liability for those instances as well, as opposed to instances where the state has recognized that there has been wrongdoing and has even prosecuted or incarcerated? And the second question had to do more with some of the practical difficulties, and you addressed that to some extent as a follow-up to Ido's question. One of the other challenges is really evidentiary aspects of how a state can prove lack of liability. There might be issues of confidentiality, and you addressed that to some extent with having ex parte hearings or having confidential information presented. I haven't seen that in civil proceedings as of yet. I'm not familiar with countries that do that. We usually see that in immigration cases or detention cases, not so much in civil tort. So I wonder how practical that is, again, being a practitioner from a practical perspective to implement those in this context. Thank you.
Wonderful. Two really interesting and really good questions. Let me talk about the first one. So the first one was whether we want to apply the same kind of standard when you think about negligence for war and peace, and how do we deal with the fog of war and uncertainty there. So one thing that I want to reiterate is that there are certain types of arguments that exist in scholarship that say that we should have this kind of same standard apply in peace and war, and that we should think about war as some type of ultra hazardous activity that's going on, and therefore there should be a strict liability regime for that. I'm totally against that. I think that completely misses the way that you think about both peace and about war. Something that's ultra hazardous during peace is entirely different when you talk about war. Obviously, you're not allowed to punch anyone in the face during peacetime. You are more than allowed to punch certain people in the face during war. So that's not the right way to think about things. But the question about the fog of war is one that's very difficult. And that's one that I think captivates judges, to a certain degree, legislators the most. This kind of thought that, and this goes to the quote from the Smith case that I brought in, right? This kind of thought that during war, it's just simply impossible, or this very particular idealistic version of warfare, that it's impossible to take any kind of precautions, take any kind of calculations into account. And I think that that's something that maybe is true for certain types of warfare in certain situations, hands down, but not necessarily for all of them. There would be instances where you do have time to take those considerations into account on a higher level, if not on the battlefield itself. Maybe you have high-ranking officers and they can say, okay, use that ammunition and not that ammunition or something along those lines. But also when we think about the fog of war as this type of argument that's supposed to exempt soldiers from taking due care, then we're missing the point that actually the law of war requires soldiers to take certain care and to think about certain things. So it's not novel in that sense. And if we accept that soldiers are not allowed to simply go guns ablaze in a scenario that's dangerous, then if that's fine for IHL, that shouldn't be something that's too difficult to think about when we think about tort liability. And again, this is where the rules of engagement would come in, because they provide this very clear structure of when you can act and what can you do. And yes, there is discretion, and yes, there is uncertainty, and courts will be able to deal with that in the same kind of way that they have before the expansion of the exception. So I think in that sense, that those are two things to keep in mind, that you're right, my account is one where you have permissible wrongs. There are certain things you can do, but I want to, and of course, this is not something that happens, this is not a peacetime standard, it's a wartime standard, but there is a standard. There is no exemption or very wide total discretion that combatants have or should have and enjoy. In relation to the evidentiary question, yes, I was talking more about cases like immigration cases, but you can try and think about whether those would be possible, right? You can maybe have designated lawyers that would have the right kind of classification, and they will be able to review certain things and liaise with the right kind of liaise with the representation. This is just a general idea that you might be able to adopt, but you're absolutely right. And evidentiary difficulties were, I think, one of the main motivations, at least in Israel, for government attorneys to expand the scope of the combatant activities exception. They were struggling with cases where they either couldn't bring evidence to support their arguments or refute plaintiffs' arguments, or they were being forced to decide whether they are going to pay or disclose information, and they weren't keen about that. And I think you can deal with these instances in a slightly different way. I think it was right for the Israeli legislators to change there isn't this ability to the burden of proof shifted from if some kind of injury happened due to some kind of dangerous weapon being used. That shift of the burden of proof was abolished, and that was absolutely right. That takes into account what we have in war, dangerous things. There are other ways. There are all sorts of kind of small practical ways where you can think about solutions. Not to say that it's not going to be difficult. I think I conceded that point to Do's question, but you still can think about a variety of ways to maybe address these issues without having a blanket immunity regime.
Thank you.
Thank you.
Thank you. Any more questions, remarks, comments, protests? So let me ask a concluding question. with regard to basically political economy. Okay.
Not within my realm of expertise, but I'll try.
with regard to the implication of your proposal. At the moment, the Israeli-Palestinian context is quite sui generis. The number of lawsuits, the Smith case that you mentioned is an English soldier, right? So the number of cases in which enemy victims sue or can sue in the country which the opposing country, I don't know empirically if such cases exist. Maybe in the United States, maybe there is one or two cases. But if your proposal will be materialized, this will not open the gates. And this means that, those countries who will adopt your proposal will be probably the countries who are independently the least violators of the law of wars and other, and they have more strict rule of engagement, while, other countries who do not do that will not adopt it. So in a sense, it will create inequality or injustice that results from this delegation of international law issues. Had you proposed tort liability in international law, that would be a different story. But since you propose it to local states, to municipal states, that means that, of course, those who will adopt it will create basically greater injustice as a consequence of war.
Okay, really interesting. I didn't see that one coming. I was thinking you were going to go in a different direction, then you surprised me. So I'm going to try and do my best. In relation to how many instances of enemy civilians bringing claims against the state that injured them, you're absolutely right, there are very few. But there are very few claims in this context, generally speaking. And the reason for that is, I have to say, maybe there are some practical reasons. Israel is very close to Palestine, and Israel opened its doors for litigation for Palestinians, and perhaps the lawyers have been trained in Israel, and so there is this sufficient proximity, and it's cheap enough, and it's available enough. So you have hundreds of cases in Israel. Not only the amount of cases that were submitted, but the amount of cases that reached a ruling. So in Israel, you have 300 of those, or at least almost 300, 292 on my account. Whereas in US, UK, Canada, Australia, combined, you have maybe 20. So that's one thing to take into account. You have the Netherlands, for example, that allows claims in tort for these kinds of things. And there was a recent case that was very important. It was the mothers of Srebrenica, and there was some kind of liability that was imposed on the Netherlands for their part in the genocide that happened there. But I think in that sense, maybe that jurisdiction is very unique. But very recently, the UK
We're talking about genocide.
Yeah. But that was a particular conflict. It was a peacekeeping operation. So that is very unique. So both the jurisdiction and its legislation are unique, and that circumstances are unique. So it's very hard to extrapolate from that best practices. But more recently, the UK saw a flood of litigation. They argued that they received about 900 cases, both in the European Court for Human Rights and in UK courts, by foreign nationals from Iraq and Afghanistan for various injuries and losses that were inflicted on them during the operation there. And I think that most of them relate to what happened when they were imprisoned rather than what happened during actual combat. So maybe we can put that kind of aside. But you can see that you have this transnational litigation happening. And I think that the reason that you have that is that you have particular law firms that are trying to push human rights claims, or sometimes, as happened in the UK, you have people who are just trying to bring false claims and receive their fees by various settlement agreements. So you have that as well. That was also mentioned, but you can see that maybe the scenario, maybe this regime is going to be taken up more readily by countries who are not violators or often violators. And that can create a disparity and can create issues relating to inequality and injustice. And I don't think that there is an easy way to remedy that. But I think that two things. One, it might start creating some kind of political pressure to maybe adopt some kind of regime, or maybe minimize the scope of the combatant activities exception. So that will be helpful, but also not having anything and just having blanket immunity. So everybody is formally equal, but that comes at the expense of injustice as well, right? So maybe we'll be willing to admit a little bit more inequality if overall it creates more, or is able to achieve more justice of some kind in some way. But like I told you, political economy is not my strong suit, and I feel like these types of arguments are hard to settle. So I'm trying to push a general account out there, and hopefully everyone will adopt it because they will see how true and valid it is. But if that's not going to be the case, then hopefully at least it will bring some kind of assistance to a certain amount of people. And I'll be happy if that's the case. I'll be content.
Thank you very much. You were very persuasive. Thank you, everyone, for joining. And we'll see you on our next meeting physically, Michal. Yeah.
Thank you very much. It was fascinating.
And enjoy UCL.
Thank you very much. And thank you again for inviting me and for these great comments and conversation. All right, take care.
Bye-bye.
Take care, thank you.